Good afternoon, everyone. Thank you for joining us. I'd like to take a moment, as always, and thank Dean Karen for being with us today. Dean of the Law School has been so incredibly supportive of these series and the real substantive things that we're trying to get to as we move forward. So this is a continuation of our Race in the Law series. We began this series in the early fall with the goal to introduce and encourage really substantive legal conversation about the way that race may intersect with various doctrinal subjects. Premised on Professor Dorothy Brown's book, we have spent time exploring what has been difficult but meaningful conversations that we were pleased to start with Professor Brown herself in September. These are not meant to be solely lectures, but rather discussions to spark thought and perhaps even research among our really gifted students, faculty, and of course even our staff. And so I am very honored today to continue this robust discussion with Dean Blake Morant. And as has been noted in the chat, our past conversations have been about the intersection of race and property law, criminal law, and civil procedure. And so today we are discussing contracts. Dean Morant is visiting us from George Washington Law, where he was the Robert Kramer Research Professor of Law and served as Dean of the Law School from 2014 to 2019. Dean Morant was also Dean of the Wake Forest University School of Law, where he built a national reputation as an exceptional law school administrator, a tireless advocate for students, and respected legal scholar. He has published extensively in his areas of scholarly focus, including contract theory, media law, and administrative law. He also has been active in national professional legal organizations throughout his career. Dean Morant was the president of the Association of American Law Schools in 2015. Dean Morant was named the John R. Kramer Outstanding Law Dean by Equal Justice Works and recognized 3 times by National Jurist magazine as one of the most influential people in legal education. Among his many accolades, he has been twice named Professor of the Year by the Women's Law Student Organization at Washington and Lee University, and received 5 awards for outstanding teaching, the University of Toledo College of Law, and has taught at various law schools. And so we are so honored to have him joining us this semester and taking the time to have this conversation with us. The remainder of the program will be as such. Dean Morant will speak for a few minutes, and then we're going to have some time of open conversation. I have prepared questions, but I welcome you to share questions or thoughts that you may have in the chat. Especially those of you who might fancy yourselves to be contract law scholars. We really would love to dig in. I have questions going all the way back, but I think it was a 1994 article that Dean Morant wrote, which may be older than some of those on the chat with us, but we're not going to date ourselves too much here. And so I think we can really get into some great legal conversation. And like I said, the goal is that we are sparking thought and research. So I hope students, like I've done at past ones, I may assign someone to do a law review article on one of the things that Dean Morant raises. That can be a really interesting area. We're not giving you all the answers. We're just talking about some of the things that we think are really important for the legal community. So with that, I'm going to turn over to Dean Morant for a few minutes to maybe share some overarching thoughts on contracts and intersections with race and diversity, and then we'll dig in a little bit more. Dean Morant.
Thank you so much, Dean Richards. And first of all, for that very generous introduction. I mean, you always are humbled when you hear people basically giving some of the stuff that you've done in the past. It's like you've read my mother's diary. And so I'm so grateful to you for being so wonderfully complimentary. Let me, first of all, thank you and the law school for having this wonderful sort of series on looking at law through this particular lens. And I'll say a little bit more about that in a moment. I definitely have to thank Dean Karen and the other members of the faculty for inviting me to be a part of the Pepperdine community. As you introduced me, one of the things that you didn't say that I'm very proud of is that I am an alumnus of Pepperdine, having received an honorary degree from the university back in 2010, and have always been a huge champion of the school. So when the opportunity to visit surfaced, I leapt at the chance to do it. because to spend time with this wonderful community would be wonderful. Now, I have to say, the whole conversation about the visit was going to be one where I would physically be there with you. And of course, the virus has sort of taken all of that away. But I've got to say, my time with the school virtually has just been phenomenal. I have a great number of students in my contracts class who have been wonderful individuals exploring this discipline with me. Um, the opportunity to sort of engage with the school like I'm doing now has been more numerous than I ever imagined, and every single one of them has been so very positive. So this has been a wonderful highlight for me, and I very much appreciate it. And thank you so much for inviting me to this series. So I'm not going to talk that much. I think, like as you said, the dynamic is so much better when we have a conversation about some of the issues. What I want to do is just sort of throw out a couple of pointers that highlight a couple of things in terms of the holistic nature of why contract law in some way implicates a conversation about race. That's first. And secondly of all, to really talk about why I had written about it in the past and consider it to be, I think, a topic worthy of discussion and quite frankly is always very timely. So let me start first of all with the whole idea of law in general. As we all know, law, which has as its foundation this whole aspect of sort of a naturalist view, which undergirds what justice is all about. And I'm not going to get into all the jurisprudential arguments. You can see that in my King's piece. But well, a lot of times I'll tell students and audiences that I talk to about this is that there's a huge connection between ecclesiastical teachings and law. If you look over 500 or 600 years ago, many of the instructors in law were clergymen. And as a matter of fact, most of the teaching came from that. And so there's this huge nexus between this aspect of justice and where that comes from. It's naturalistic principles, which have to do with sort of thoughts about human nature and freedom and all of these variety of different feelings and what have you. And a lot of times we judge the efficacy of legal principles based upon whether or not they fulfill those fundamental notions of justice and right and wrong and those types of things. And we can have a further conversation about the jurisprudential nature of that in terms of why that is important as we look at law. But if you look at how law operates, it's there in order to give a certain series of rules that help individuals to interact and to transact and to enjoy the natural liberties that come with those kinds of opportunities. And one of the fundamental natures of that is that you really want to make sure that anyone can have the advantages and the enjoyment of having those types of freedoms and those types of enjoyments. And so when you look at law through that lens, then oftentimes what you want to do is determine whether or not the law is truly functioning in a way to further that. And I have always said, and I still believe this, I've written about this, and I think that there are many others who've probably done this in a much more concentrated form than I have, is that a true test of the efficacy of law in terms of its manifestation of justice for everyone is whether or not, when you put those laws into operation in context, whether they function the way that they're supposed to function. And this gets me to what my position has been with regard to that. I am a contextualist. I am an individual who tests legal theory and law in terms of the context in which they operate. And if you do that, then you have to evaluate law in terms of how it basically ferrets out its efficacy in terms of justice for everyone And how does that operate within the context of how human beings actually interact with one another? And when you do that, then you have to look at a variety of different contextual variables that tests the law's efficacy. And that's where race comes in. And it's not just race. I should say it's any kind of human difference that basically sort of comes to the fore in terms of how people interact with one another. How does the law deal with that when you have these sort of humanistic types of values that people bring into every single action and reaction that they have when they deal with one another? And that's what a contextualist does. And so when you do that, then you test the law in those variety of different circumstances. What if the parties are different instead of being the same? What if parties who are dealing with each other are different in terms of their race, gender, beliefs, backgrounds, religious backgrounds, ethnicities, nationalities, all of these variety of different things? And we all know, the social psychologists have told us that many of our reactions of how we deal with one another enter into our thought processes in evaluating how we do actually interact with one another. And we don't necessarily shut that off just because we have these legal rules that are there to really guide our behavior. So when you look at that and you look at contract law in the abstract, it has a very classicist, and I've told my students this, it has a very classicist sort of base to it, that it's egalitarian. It applies to everyone the same way. And that's the way contract rules are supposed to be. We have these rules of engagement. You follow these rules, you will be secure and have certainty with regard to following those rules. Your expectations are going to be met. And if they're not met, then the rules also provide a remedy for you in case that hasn't been done. And so on its face, those rules look very colorblind, very egalitarian, and we tend to like that because it's easy to apply. Either you follow the rules and you get what you want, you don't follow the rules and you don't. But we all know that when people interact with each other, when they transact with each other, their own belief systems come into play as they are going through the mechanisms of those transactions. Individuals who perceive people as being different in some way, that is a natural thing for them to do, to size that up in terms of how should I bargain with that person? And this deals with a number of different traits: their experience level, how young they are, how old they are, whether they are individuals who are familiar with the trade and practice that's there. Maybe they're not. And all of those things enter into the sort of mental processes that people go through when they transact business. So if you know that, then why is it that we do not test the efficacy of law in terms of actual human behavior, of individuals sizing each other up to determine what kind of bargain can I make from this individual? What can I do in order to make sure I maximize my particular desires and expectations in this bargain based upon what I think about you and what I know about you? And when you look at it that way, then we are not being genuine in really testing the law's effectiveness without looking at all of those particular variables. So now, I don't want to talk to you because I can talk about this forever, but let me just say for now, when you have that as a basic construct, then you ask yourself, why is it that the law is not dealing with those kind of contextual realities more often when they're trying to determine whether those rules work well or not? And that's where folks like I and others who sort of test law in that particular way, we look at the context in which these laws are being applied and ferret out exactly what are some of the manifestations of that when we have these human traits that are there. And as I said before, there are a number of us who've done this. I point to, and I have cited this before, Ian Ayers, who's a big contract scholar. He's at Yale, but he also is a contextualist, and he did this wonderful article. And I think it appeared in the Chicago Law Review. If it wasn't in the Chicago Law Review, that's coming into my head because he tested this theory in a Chicago market. And this article sought to prove that even though we have these classic rules of contract that basically apply to everyone and are egalitarian, and you follow them and you get these sure results and all of these variety of different things, he tested that theory in an empirical study with used cars. And in this study, he basically looked at a variety of different buyers of different backgrounds and different characteristics. A woman, a person who was of a more disadvantaged class, either economically or some other way, someone of color, all of these various things, and basically took these individuals who had similar economic situations. In other words, their income, their availability for credit, all of those things were pretty much sui generis and fairly standard across the board. And noted that each one of those individuals who negotiated a deal with this used car company got different deals based upon their backgrounds. And so that empirical study, and you're finding this a lot in a lot of the contextual studies that deal with either race, gender, or some other sort of manifestation of difference in terms of individuals, you'll find that those kind of tests confirm the fact that even though we have these egalitarian rules, that individuals have their own sort of belief systems as they are transacting business. And those come into play when they are actually putting these deals together. And then the question becomes, does the law recognize that? I mean, once those deals come forward and a problem happens, whether there's either non-performance or someone sued for breach or whatever, how does the law deal with the fact that when these people came together to bargain, the bargain was put together in light of the belief systems of the individuals based upon how they perceived that other person? And then we begin to find out that, particularly with classical contract theory, there's very little there to sort of deal with that. Now, as we have studied in most contract classes, there are some concepts that tend to apply this contextual reality in terms of remedies for individuals who are caught in bargains that tend to be either one-sided or improvident, and that's the unconscionability doctrine. And you see a lot of scholars talk about that when we're talking about race in terms of a remedy for that. But if you think about it, that's only one little doctrine, and it comes into play only after the bargain is actually struck, only after the individual is pretty much caught in a bargain that seems to be improvident. And it also means that individual has to have the wherewithal, financial and knowledge base, to know that they can challenge that particular bargain that they're in based upon that concept. And if that's the only thing we have in contract law, then it stands to reason we're going to need these critiques in order to make sure that the rules that were brought up to be egalitarian and to be fair and to apply to everyone, that those laws ultimately do what they're supposed to do. So these critiques are very important in order to be able to test whether the laws are doing what they're supposed to do. And if they're not, we need to propose things to make sure that they do. So I'll stop there.
No, that was all, so interesting. And of course, you raised unconscionability, which I have so many questions and thoughts on as well. But I'm wondering, though, you mentioned testing the law and the remedies, and this may be something that, I'm asking outside the bounds, but what remedies do you think we could create to make sure that the laws are functioning the way they should? Because you're right, unconscionability is one small policy that we could go with. What else? If we were to reinvent contract law right now, what could we create?
The Blake Morant theory of contract law.
Workshop it, right? The Blake Morant theory of contract.
Oh, I love it. Oh my goodness. That's a contract teacher's dream, right? What should the law be based upon my view, right? Well, here's where I start. I can't give you a laundry list right now, because I think what we need to do is sort of lay out all of the various sort of postulates about contract. And I can say, in this one, we should do this. We should let me give an overarching sort of remedy that can be done right now, that I think doesn't upset the apple cart in terms of taking all of these contract rules and then readjusting all of them right now, because we know that's going to be a Herculean task that won't happen right now, right? The one thing that I think that can be done right now is to raise awareness among those who are actually deciding these disputes about the reality of how people bargain and what should be taken into effect when we evaluate those bargains. See, that's why unconscionability becomes very key, because it opens the door to talking about those variety of different things. And the standard case in unconscionability is the one that's cited in most contract case books. It's Mrs. Williams versus Walker Tama Furniture Company, which, by the way, was in Washington, D.C., where I'm now ensconced at George Washington. And it's your classic case because you got to get into the contextuality of the bargaining positions of the parties in order to determine whether or not that ultimate agreement is fair. And so if any of my students are in the audience right now, they could cite to you right now, you need two basic criteria there for unconscionability to apply. One has to be, it has to be substantively unconscionable, and that has to do with looking at the contract that the person went into, and something about it has to be overly onerous, unfair, burdensome, unfair surprise. It's the actual text of the agreement itself that sort of conjures up a notion of anybody reading it. My God, this thing is just really unfair and bad and those types of things. But you also have to have, in order to get the remedy on unconscionability, it has to be procedurally unconscionable. And that's where you look at the parties. There's got to be this disparate bargaining position where you have one that's in a better bargaining position than the other, where the disadvantaged person has very little choice in the matter and therefore feels that they have to take this bargain or it's nothing, and that the other party is in the position of really putting down all of the terms that are going to be advantageous to the advantaged party and most likely disadvantageous to the other. So you got to have both of those. And what's beautiful about that in terms of being able to test the efficacy of contract law is that it is a prescribed notion that allows you to get into all of those contextual factors that define the party's bargain. So what I would like to see, if we had the Morant contract thing that could immediately be put in, is to have judicial decision makers think about that, not just in unconscionability, but whenever they're seeing a dispute that basically comes up. So let me tell you what I mean by this. Right now in my contracts course, we're now looking at how do we interpret contracts.
I'm not interrupting you for anything, but to say to students who may be in your class, this is an extra time to take out some pen and paper and throw things into your outline. You're getting some gems right now for your final. Just put that out there.
Right.
A little wink and nudge.
So there are assiduously writing down. This is what you said in that special program. Right? So, and I love them for it. So what I think would be great is for decision makers in the interpretation of contracts is to keep in mind that when these parties started bargaining, they were sizing each other up in terms of what should be in the contract itself. And so when you're interpreting what their duties are supposed to be and all of these things, keep in mind those humanistic factors, that these people have sized each other up during the bargaining process, and they have entered that either objectively or even subjectively or implicitly or expressly in the terms of the contract and how they would like for it to be performed. If you keep that in mind, then as you interpret what should be done by the parties, then you can have a much more realistic view as to whether or not this particular agreement is the kind of agreement that the parties really wanted to have and therefore should be judged that way. Or at least it will make you ask probative questions to the parties in terms of what their true intent was when they actually came into this agreement. And so my biggest thing, without elongating this, is instead of, and I'm not saying that we don't need to fix other particular points of contract law, and I think that eventually will happen, but it's going to be over a span of period of time as people look at this. But whether we can get decision makers, people on the jury, judges, to think probatively when they are interpreting these disputes in contract about what brought these people together in the first place and what possibly entered their minds in terms of whom they're bargaining with, their presumptions, their generalizations, their thoughts about those individuals, and how that ferreted into their belief system in putting together the bargain that ultimately came forward. And that's why Ian's work in that Chicago used car case is so wonderfully probative. Because if you look at the agreement just in the abstract of those people, it wouldn't tell you that I think when the car company bargained with this person, they were doing it like they would do it for any other regular person. But then when you look at the contracts themselves and you say, oh, but this has this in it, this has a better warranty than this one does, or this one doesn't promise as much as that one does. It confirms the fact that when these parties got together, they utilized their own preconceptions about the people they're bargaining with, and that influenced what they would do in terms of how they would bargain with these individuals. That's my overall manifesto.
Well, so I think homework assignment number one is someone's working on a note or a comment right now and thinking about what it's going to be. I have a title, Proving the Blake Morant Theory of Contract Law. They can go from there.
Love it. I love it. And if they do that, I promise to always cite that note in my class whenever I teach contract.
Come on, people. We've got a clear area of scholarship emerging right now. You know what, though? This makes me think, right? I can see people being concerned, and this has even come up in the unconscionability conversation about whether or not starting to have these questions will reinforce negative stereotypes that people already have. You know, so if they're being told, think about this, I saw one scholar, of course, right this moment, I can't remember the name, raised the concern after the Williams and Thomas Walker case that what we were doing was reinforcing stereotypes that incentivize Black people, particularly Black women, right, at the time, and saying they do not have the power to bargain. Perhaps the even discriminatory thoughts that people have had regarding the intelligence of people who are Black or maybe even are disabled, right, or children and so on. And so if we move into this area, what are your thoughts about that? What are ways to do it that don't create a policy that says these people are less able, these people are stop trying to lead them fit?
And that's a very astute observation, but it also proves my point, right? And this is my point, that people basically, and the social psychologists will tell you about this. And if you read some of my scholarship, I quote the social psychologists on this, is the natural human nature to apply your preconceived notions, your generalizations, your stereotypes. It is a natural mechanism of digesting lots of information to do just that. What we don't do is challenge those preconceptions so that people will not default to those in terms of their belief systems in general. And that's what we have to do in terms of making sure that individuals are aware of the fact that it's a natural thing for you to do just that. The social psychologists have all documented it with great study. And I've cited to this Jody Almore, who's on the faculty at the University of Southern California Law School, has done amazing work on this reality in criminal law, that when we are looking at anyone, before they say anything, we basically make judgments about who they are and what they can do and whether they're friendly or not, and all of these variety. It is a natural human thing to do that. What has to be done is to first raise awareness of the fact that people naturally do that. And secondly, that they not default to those as their belief systems as they go forward in their transactions with other people. And that second part is the part that's really very important, because unless you raise that awareness in people that they have that tendency, they will just default to it and may not even realize that they are defaulting to it. And they'll just assume that that's the case. So as that is a predicate to answering your question, which goes along the lines of when we explore these things, like as we do in unconscionability, doesn't it reinforce those preconceived notions? And there's no doubt that could be a worry unless you marry the conversation with one that includes a variety of different people who have that exact same sort of criteria or characteristic that are not just of this one person. So let's think about this a little bit. If you look at the Williams versus Walker Tama Furniture Company case, as is cited in many different case books and contracts, there's no mention in the digested case that this is an African-American woman. They talk about her position as someone who is on government assistance, which, you know, when you say that, that conjures up certain kinds of pictures of individuals, right? And people have written about this. The majority of people who are on government assistance are not African American. So, you know, all of these kind of criteria need to be put in terms of the universality of them. So if you're talking about Mrs. Williams, who happens to be an African American woman who's on government assistance, who has more than one child, and all of these, there are many people who are not African American, some who are not women, who have those exact same characteristics that Mrs. Williams does. And so it's important to bring that out so that you short circuit that automatic default mechanism that people have in their belief systems about who basically is the type of individual who's going to be caught in these particular situations and who will be getting the remedy from these. I will venture to say, and I haven't done this study myself, but it would be interesting for someone to do an empirical study to see the backgrounds of individuals who have basically gotten a remedy through unconscionability. And I haven't done that study. I think it would be an interesting one to see. I would be not surprised if the majority of people who have gotten that remedy are not people of color. And I would say that from this standpoint, access to justice, because many people of color who don't have the means, don't have the access just to take a case to that particular level in order to do that. And most of the cases that do go to that level are by individuals who have the economic means in order to push it to that level. And therefore, that's, again, if you look at all the contextual realities, that most likely most of the people who get those remedies are not necessarily people of color. So what we need to do is, when we have those discussions, we talk about the universality of the characteristics so that it short circuits that stereotypical notion of who these individuals are who are caught in these particular situations.
So I hear a couple of further research notes coming out that I hope people are writing down for their own scholarship. One is that empirical study that you mentioned, right? Wanting to see, let's look at these remedies and who's getting them, who's benefiting from this policy that we have in place. But I hear a second one where someone could go back, and it's long been a thought of mine as to why in our various contract law cases we don't get more of the characteristics, more of the demographics. And I'm not just speaking about race or gender or even sexuality, but just tell me more about these people so that I understand what I'm walking into, right? And what I'm reading. And I think that would be fascinating as well. Someone going back to the trial record, getting that information and now putting it into the cases that we're reading that are so commonly taught to go, with this information in mind, how are we interpreting this case? With
and
this information in mind.
That's a wonderful observation. And I, being the teacher that I am, I'm going to refer back to what I said at the very beginning when you gave me the floor, right? And that is that contract rules tend to have this sort of facade of objectivity to them, right? I mean, they tend to sort of, you read them and they're objective looking. They're objective. It applies to everybody. You read the rule, it applies to everybody, and everybody has to do what the rules say, and therefore there aren't these distinctions based on race, gender, sexuality, nationality. It's not, because you read the rule and it reads to be objective. But what we understand is that when the rules were originated, they were not necessarily originated with the idea that human beings are going to apply these things and they're going to do them in light of their own sort of belief systems when they do them. Secondly, that when the rules were originated, and I'm going to give the drafters of these rules every benefit of the doubt, that they were sort of saying, anybody can avail themselves of the remedies of these rules. It doesn't matter who you are or what class you are, what race you are, what gender, whatever. Everybody can have this remedy. And it looks like that's the case. But there are all these contextual realities that sort of suggest that it doesn't necessarily apply that way. And we've already named some of the contextual realities already. Quite frankly, so think about this. All of the rules of contract formation are really hundreds of years old. And prior to the 20th century, the classicists ruled that. And with this idea, they apply to everybody the same. Everybody gets the same. You apply these rules, you go by the rules, your expectations will be met. Contract, if you basically follow all these rules, will be enforced, and therefore you're going to get a remedy and everybody wins. But it really wasn't until the 20th century that individuals who basically exercise these doctrines recognize that when you put them in a human context, things go wrong. Not everybody gets the same thing when these rules are out there. Not everybody gets the same kind of deal when they're out there. And that humanistic factors such as wealth maximization, the economists will talk about that, opportunism, bias, all of those things come into play when people are bargaining with one another. That's what happened in that study that Ian Ayers did, because that car company said, well, if I'm dealing with somebody who doesn't have as much money and are not really savvy with regard to doing this, I can get a bargain that's going to be more advantageous to me. And all of the economists out there will say that's what human beings do, right? They're maximizing their wealth by getting the best bargain that they possibly can, even if that means that they're taking advantage of some of the factors that they're sizing that other person up for in terms of doing that bargain. And so it wasn't until the 20th century that basically speaking, those who study in contract law said, we need to have something else in there that takes a much more realistic approach of looking at how these rules actually ferret out. That's when all of the regulatory norms start coming in. Incapacity due to age or mental capacity, duress, where, you know, and my contract students will tell you this, we got physical duress and we also have economic duress. And with physical duress, and that's the one that's so easy to teach, person puts a gun to your head and says, you better take this deal. And you go, okay, I'll take this deal. Now, if that deal isn't performed, if you didn't have those contextual realities about the gun to the person's head, this contract looks like it's totally valid. But we all know it's suspect because the assent of the person was forced. It wasn't until the 20th century that those kinds of regulatory norms, the capacity, things like duress and unconscionability, which were a result of recognizing how individuals bargain and those contextual realities that come into that. So we need to recognize that as a fundamental notion of testing these classical, seemingly objective rules so that we can put in the heads of the decision makers who apply these rules. Yeah, the rule looked like it's objective, but when you actually look at the context in which the rules were actually used in order to come up with this, there were certain inequities that basically came forward, and you need to know those before you come down with a decision.
You know, this brings to mind, and your same students may be hearing echoes of a conversation we had in my class in February. It brings to mind to me a lot of the questions that I think come up more in torts than in contracts, right? About when we say the objective person, the reasonable person, who do we have and who immediately comes to mind as objective and reasonable? Now I'm saying to those students, let's carry that over to contracts. So when we say, you know, who comes to mind when we think about someone for whom this contract is bidded? Yeah, who's the reasonable person in all of this? Y'all would be so ashamed if I told you the way I bargained for my first car, which was not at all, you know, and later people were like, you saying how much for what now? And I don't know. They told me this is what it costs, and I signed the paper.
Right.
And I went to law school.
Well, you know, and quite frankly, everything that you say rings so true in so many ways. And just as you said, in torts, you know, they do deal with this concept of reasonableness in a much more universal way, right? What would the reasonable person do in terms of judging whether or not they've breached their duty of behavior in terms of whether or not another person has a cause of action? Actually, in contracts, even though in contract it's not as obviously holistic as it is in tort law, the reasonable person comes in a lot of different areas in which we apply this. And my students will tell you, we talk about this quite frequently, particularly where you have a contract where we know the parties have come together and admitted that they have a bargain. We admit we have a bargain, even though we've left certain terms out of that bargain. And so when the court's convinced that these parties truly intended to bargain, that there is a contract here and everything like that, although the parties left certain terms out, which might signal that they didn't have a bargain. But if we're comfortable enough with the fact that they did have a contract and wanted to bargain, we'll fill in those other terms based on reasonableness. And sometimes those terms may be given to us in terms of the Uniform Commercial Code if we're dealing with Article 2 and the sale of goods. But in other situations, we look at what the reasonable person would do under those circumstances and how would that factor in terms of filling in some of those terms. So we have that as well. And I think the comment that you made is a very interesting one. So when you are asked, who does that reasonable person look like or is seem like? What comes to your mind first and foremost? And when you ask that question, then you get to see what our preconceived notions are that we apply to whom we think fits that label. And that illustrates why we have to do this contextual evaluation of these rules in order to make sure that the person making the decision of whether or not we're going to enforce this or not knows that. So they keep that in mind as they're making their decision.
Absolutely. Well, I want to pause for a second because I'm looking at the time. I see we have about 15 minutes left, and we get so caught up. I want to make sure that anybody, any of our attendees who may have some thoughts or questions that have been raised based on this conversation know you can, if you want to be recorded, you can use the raise hand feature and speak out. It's not class. We're not cold calling you, right, Dean Morant? We're giving you the option. And if you want to use
darn, you mean we can't cold call?
We're not cold calling them now. If you'd like to use the chat and drop in any questions, you can. And I'll give the opportunity for that. While I ask this, I am curious, Dean Morant, of the thought that many great civil rights victories were first won on economic front, right? So, for example, finding race discrimination in a place of business violated the UCC. It was one on the economic front before it was ever run, at least in my mind, on the moral front that we would hope it would be run on. So I'm wondering, do you see a landscape for continuing to use economic and contract law principles to advance racial and other forms of equality? Or do you think, we've kind of done what we could with the contract side of it, and people may need to turn to other ways to advance these theories?
Yeah, that's a wonderful question. And I could talk about that forever too, but I want to make sure other people get a chance to sort of ask questions. But you bring up a wonderful observation. A lot of the advances that we've made in human rights have been done on the sort of back of economic sort of justice and economic principles. I mean, if you look at a number of the civil rights laws that came out in the 60s, many of those were enforced based on the concept of interstate commerce, that if you're involved in interstate commerce, then you have this obligation in terms of not discriminating against individuals who either will come to your establishment or whatever. So they do have an economic, I would say, foundation to them. And I think that suggests a couple of things. Of course, if you were to talk or do some of the background in some of those statutes, you would note that many of the people who were trying to get these changes were trying to figure out a way that people would adopt them. And you'd like to think that people would do the right thing that's morally right for them to do. But in some people, at the end of the day, economics will certainly push them to doing the right thing. And certainly, if you're someone engaged in interstate commerce and you decide you want to discriminate and you no longer can get this flow of individuals coming through because you want to, instantly you'll stop discriminating in order to do that. And so I think it's a two-pronged strategy. I think it's one that gets people to do this because it's in their economic interest to do it. I think the other way is that it gives you a sort of legal framework in order to improve the efficacy of those laws so that people actually do follow them. So I do see that as a primary prog. I think going forward, and I think you said, is that still going to be a linchpin? I still say it's going to be. And I think the reason that it's going to be is because of what I said at the very beginning. People tend, for better or worse, to go with what's in their best economic interests. And so if that's a fundamental nature of human nature, as we've sort of alluded to already in this, and that's a contextual reality, then marrying a lot of what needs to be done in order to really short circuit bad behavior based in bargaining theory is going to have that as a sort of initial foundation. And here's something that's more positive about that, right? Because right now we're talking about, oh my God, people only do this stuff if it's going to inure to their financial benefit. But note this too. I think once people learn that discrimination is not a useful tool, that eventually it seeps into their consciousness in terms of not doing it, even when the economics is not great. And there's some studies that have talked about that as well. I mean, over time, when people have begun to do this, it gets them to challenge their basic belief systems about certain individuals whom they would like to frequent their particular establishments. And now they've begun to see, boy, you know, they're people that I don't want in my establishment, even if they look like me, because they do the kinds of things that they're not supposed to do. And people begin to learn that. And once they do, and social psychologists have said this too, it gets them to break down their preconceived notions. But I think at the initial outset, when they're so rigidly sort of married to those notions, you need to have something that pushes them in that direction. And that the civil rights laws basically prove that.
Wow. Thank you. I see another, giving someone else another note or comment to write about that, right? And the idea of legislating morality and how we move economics towards people's movement forward. But we have a couple of questions in the chat, and one was going back to, both kind of really go back to what we've been talking about with the preconceived perception. So one person, Dale, asked, how can we control the scope of our preconceived perception? We've talked about who immediately comes to mind when we think of the objective, when we think of the reasonable, even when we think about the contract. And you said, that we need to be aware of that and then move from that. How do you control the scope of that? Do you have any thoughts?
Okay, when you say control the scope of
the preconceived perception. So perhaps once you're aware that it's there, now what?
Oh, okay. How do you raise it? What do you do in order? So here's the good, and then I would give you the good, then I would give you the challenge. So the good is what the drafters of these rules had in mind from the very beginning. And again, I accord the drafters with a great degree, I give them a great degree of benefit of the doubt. And I'm thinking at the core, they probably said these rules apply to everybody the exact same way. Now, I can be challenged on that notion on a number of different fronts, mainly because many of the people who did the drafting were economically privileged people in the beginning and are probably drafting these rules to their advantage anyway. So, you gotta put that on. But if you just read the rule and you read it, and let's say you're an individual who didn't draft it, but you're applying this rule, you read it, it doesn't seem to be a rule that's subjective. It tends to be somewhat objective. And if you take that on its face value, I think I go back to the suggestion I made before, is that it's going to be important for we as attorneys to enlighten those who are applying these rules to the realities of the context in which these rules are actually being applied. And so when we're talking about scope, and I'm not sure if I'm answering that quite completely, I talk about it in terms of being, and I've said this when I've talked about unconscionability to public interest lawyers, because many of them will come to me and they say, what you're saying makes a lot of sense. We're in your amen corner. We agree with all, but when I'm in court, we just got to plead this thing, and it's this and that. And one of the things that I tell them, and I'll share this with the audience, is if we are really good lawyers, we don't want to leave any stone unturned when we're trying to get the judicial decision maker to take into account everything that's important in terms of making a decision based on this rule. If you go by that principle, then you've got to raise the awareness with that particular decision maker about these contextual differences, so that they put in their head that that's a realistic kind of factor to take into account with this. I gotta say this when I say that point. This is why we need diversity in our profession. That's why we need diversity in our profession. When we have individuals who come from the same backgrounds all the time that are in these positions, they have no conceptualization. If no conceptualization, they don't immediately think about the differences that come into play when these people are applying these different rules. When you have people who come from a variety of different backgrounds, those individuals oftentimes, not always, but oftentimes will think about these issues, these contextual issues to bring up. And it's our responsibility as very good lawyers to present all of those to the judicial decision maker. So as they are trying to make a decision about the efficacy of this particular bargain, they keep that in mind. Now, does that mean that the judicial decision maker, when they hear me talk about this, is going to say, oh yeah, you're absolutely right, I'm going to find it? Probably not. But will it be a factor that they either have to confront if they ignore it? And the answer to that is yes. And if you've done that, you've begun to open the door, at least in terms of making sure that those realities are taken into effect when they're applying these rules.
I think in that you answered maybe, or partially answered the other question that was in the chat about how do we educate those decision makers. And I'd like to, if I may, maybe I'm in the Blakemore School of Thought now, and you'll grandfather me in, but a piece of advice that I would have is to remember, especially if you're at maybe that trial court level, right, or you're in a mediation or something, always remember that you're building that record. So the decision maker at that level may not agree with you. They may, as you said, Dean Morant, go, okay, yeah, this is a bunch of fluff, right? Or it's hooey, we don't think about that. Contracts is neutral. We don't do that touchy-feely. And that's fine. But if you're thinking, what if I have to appeal this, you've got it in your record. You raised that as an issue.
That's a
wonderful. And that might just be that's the litigator in me that's always like, have it in my record so that if I want to appeal on this issue, no one can say, well, this is an issue of first impression, you haven't raised it, we can't go into it. No, I told the judicial decision maker that there were inequities here that were not being considered. They chose to move past it.
Yeah.
But now when I appeal it, you have to confront it again and perhaps even have to explain, here's why I did or did not take it into account. I can hold your feet to the fire in another way. I don't know. You tell me if I'm right or wrong on that.
No, you're spot on. And I'd like to add a bit of jurisprudence that supports that notion. And let's go back to Williams versus Walker Thomas Furniture, where in the original case, Mrs. Williams lost that. It wasn't until it went up on appeal that she was able to prevail. And that proves your point to a T, because obviously the trial lawyer put that in the record. The lower court judge dismissed it, probably thinking, I'm looking at this objectively, these rules are objective, therefore, no, she loses. She signed the contract, it's airtight. She asked to go ahead and give back all the appliances, even though she had paid for many of them. But the contract says you forfeit all of those if you do. And it wasn't until it got to appeal that you had the appellate court utilizing the kind of analysis under the unconscionability doctrine, those two prongs, in order to determine that that term in the agreement was unconscionable. So that documents exactly what you're saying, Dean Richards. Even though, and this is what I told the public interest attorneys, even though it may be another empirical study, eight times out of 10, the judge hears it and then goes the other way. You've built a record. And so as a result of that record, if it goes up to appeal, you have an excellent opportunity to get a whole new judicial decision maker who's going to have a clerk, who's going to do the thorough research, who will read Professor Morant's article, and then will say, Judge, you've got to treat this additional information as being critical in terms of doing this. But in all seriousness, It just documents exactly what you said. You have to create that record. And in addition to creating that record, you're planning in the decision maker's head that particular fact. They're going to have to affirmatively discount it. And that makes them think at the end.
Well, clearly we could keep speaking forever, but I see somehow this hour flew by. I don't know. It just dawned to me. But, it brings to mind, you started off by saying there are many ecclesiastical traditions embedded in the law. And that brings to mind a point that you see in the New Testament, that one plants, one waters, but God bears the fruit, right? And so in this context, I think it can be so frustrating to the person in the chat because, attempting to drill that education can get you in trouble. It can create a difficult place, but perhaps remembering I may be the person planting the seed. The next person may be the one watering the seed eventually. Yes. Eventually, our seeds of equality, justice, human rights will bear fruit. It will bring an increase, even if we don't automatically see it.
Absolutely. And can I just add one? And this is shameless self-promotion, but in 2004, I delivered the Sir Thomas More lecture in Canterbury, England. And Sir Thomas More was Lord Chancellor of England back in the 16th century under Henry VIII. And if we're talking about the ecclesiastical underpinnings of law, here Thomas More, who studied to be a priest and decided instead to become a lawyer, but he took all of those learnings that he had into his practice of law. And as a result of that, that whole concept of how to look at rules in a way that furthers justice is a time-honored tradition in our profession. And I'm so glad that you've captured that. You can see more about that in my piece on Thomas More. If you plug my name in and Thomas More, it'll pop up. And we can talk about that another time too. But anyway, it's a huge point that you've made, and I just want to underscore it.
Thank you, Dean Morant. Thank you so much for your time and start having the start of this conversation, hopefully not the end. Like I said at the beginning, we want to spark thought, we want to spark conversation in our community, in the legal community. So I'm going to hold you to coming back and having Race and Contracts Part 2. And we can dig more into the Dean Morant School of Thought, write that law review article that you'll cite everywhere, and move forward. Thank you all so much. This recording will be available on our diversity page that you can go back to. You can cite to this even if you want to. We'll find a Blue Book format for that. And we will continue to hold these conversations, not only this year, but in years to come, to help deepen our substantive knowledge about how race, diversity, and all of these issues further our understanding of the law. Thank you all so much, and have a wonderful rest of your day.
Thank you so much. Thank you, Dee Richards.